front, couldn't we? If no one comes.
I could do it at the back. Oh, it's Paul.
Oh. Right, thank you. If everyone's now ready, we'll go ahead with the afternoon session. And first of all, it's Jeff Deegan giving the first part of the update on private law children.
Hello, good afternoon, everybody. Can everybody hear me okay? I'll take that as a yes. I'm going to do a children law update, but by way of cheat and diversion, I'm going to start with something else. I'm just going to talk about QLRs, Qualified Legal Representatives, and I'm doing that for two reasons. The first reason is, anecdotally at least, I'm told that more and more people are acting as litigants in person, and if that's right, you're going to find that there are more QLRs involved in cases. And the second is, I need to do so to pad out my 25 minutes. Now, you, of course, will all know that where allegations are made about domestic violence, then the court will have to consider, if people are acting in person, whether a QLR should be appointed to act for both the perpetrator and the alleged victim. And it will do so if it considers that there is no satisfactory alternative to appointing a QLR. And absent the parties instructing their own lawyer, it's difficult to know what a satisfactory alternative to a QLR would be, because it's been made quite clear that a judge asking the questions is not a satisfactory alternative. Now, I do, for my sins, do a bit of QLR work, and I know that the question often arises as to what a QLR is expected to do. And there is confusion not only from the litigants, but also from the lawyers on the other side, and from judges and justices. I don't know if any of you ever act as QLRs and whether you've experienced the same problems. But almost inevitably, if you're acting as a QLR, as the case goes along, although your role is to ask questions of the other side, the judge will look at you and implore you to cross-examine the CAFCAS officer, might want you to make closing submissions, and possibly even take instructions and see if you can negotiate with counsel who represents the other side. And that happened to me recently, and I had to refer the judge to the case which I'm just about to mention to make it clear to him that really it wasn't my role to take instructions and to negotiate on behalf of the person I was asking questions for. And that case is AXA and BYB. And it set out a useful reminder as to the scope of QLR duties. So what they can do is that they can elicit information from the person they're acting for, in inverted commas. But what they can't do is they can't take instructions. They can ask questions of the other side, but they can't represent the client beyond that. They can't negotiate with the lawyer on the other side. They can't make closing submissions, and they can't draft orders. Also, interestingly, they can't assert client confidentiality. I'm not sure how that would work in practice. Is it possible that the judge could say to you, well, Mr. Deegan, please tell me everything that Mr. Smith has told you during your discussions, because none of it is confidential. It's not happened to me yet, but perhaps it will. The question then arises, well, what if there is no QLR? What if one's been appointed but they don't turn up? Well, that was dealt with in the case of Re Z in 2024, And Sir Andrew Macfarlane gave a useful guidance on what the court should consider when a direction for a QLR has been made, but the QLR hasn't been obtained. And what he said was the lodestar for a judge who takes on the task of asking questions on behalf of an unrepresented litigant must be fairness. In every case, fairness should require the court to be very open with the parties as to the process that's going to be adopted by explaining what's to happen step by step in short, straightforward terms. The court should explain that its role is of asking questions in order for the hearing to proceed in the absence of a QLR, and that there's no satisfactory alternative. And what Sir Andrew Macfarlane made clear was that when judges are giving that explanation to the parties, they should make it clear that they're not cross-examining, they're simply asking questions. Not sure what the difference is, but I suppose it's a difference of emphasis as much as anything else. That being said, I'm sure there will still be judges who will dive in both feet first and remind themselves of their days at the bar and ask some hard questions, but there you go. Next subject I'd like to cover is parental responsibility and a couple of recent cases to look at. So the first thing to remind ourselves is, what is parental responsibility? Well, parental responsibility is the rights, responsibilities, and duties that a person has in relation to a child and their property. Who acquires PR? Well, the birth mother has it automatically, or a parent who is married or in a civil partnership with the birth mother. They too acquire it automatically. Can others acquire it? The answer is yes. If the other parent marries or enters into a civil partnership with the birth mother, or they're named on the birth certificate, then they can acquire PR. They can acquire it by virtue of a court order or entering into a PR agreement. And also, they could acquire it should they become the child's guardian. So, issue of parental responsibility was considered by the courts recently in the case of KL and BA. This is a slightly unusual case. What happened was that the father, in inverted commas, was named on the birth certificate as the child's father. Subsequent testing, however, showed that he wasn't the biological father. The parties separated, and the child continued to spend time with the father until this was stopped by the mother. I pause there to say I don't suppose any of this would have become an issue unless the parties had separated. The mother then sought to have the father's parental responsibility removed, and there was an argument in the court as to whether the father had parental responsibility up to the date of the hearing, or whether in fact his parental responsibility was void ab initio, as contract lawyers might say. In other words, he'd never had parental responsibility. And that was the view that the court took. It took the view that he'd never had parental responsibility, and the reason for that was that, firstly, the biological link identifies a man as the father of the child. When that biological link is displaced, then the status of the man as the father can't continue. And a man who's not the biological father can't acquire parental responsibility purely because of a mistake or a misrepresentation in registering the birth. The registration of the birth is simply the evidence of parentage and no more than that. The next case, and this is from an appeal from His Honour Judge Tolson KC, which went up to the Court of Appeal, concerned whether it was appropriate or indeed the court had the power to grant one party overriding parental responsibility over the other. What happened in this case was that there were two children, and they were aged 9 2004. The parties separated in July 2022, and there were then private law proceedings. Because there was such a degree of parental acrimony between the parties, the local authority issued public law proceedings and became involved. There was then a contested final hearing in February of last year, in February 2024. And during that, His Honour Judge Tolson made a number of findings that the father had been the victim of domestic abuse from the mother, and that she'd been controlling and obstructive with professionals. He went on to make a shared lives with order 50-50, which was in line with the guardian's recommendation. And he also gave the father overriding parental responsibility in relation to 3 specific matters, one of which was education, another of which was therapy. The order went on to provide that the father was to consult with the mother on those specified issues, but ultimately, in the event of disagreement, he was able to make the decision. But there was then provision in the order for the mother to apply back to the court in the event she was unhappy about his decision. The mother appealed, and the case went up to the Court of Appeal. The mother appealed on a number of grounds, the first of which was that she sought to argue that the court did not actually have the power to make an order for overriding parental responsibility, but she didn't pursue that point. The second ground of appeal was she said, well, even if the power exists, on the facts of the case, His Honour Judge Tolson was wrong to make the order here. And what the Court of Appeal said was that the court did have the power to make overriding parental responsibility orders, but it said they should only be used in extreme cases. And it highlighted some examples of where it considered such an order might be appropriate. For instance, where one parent is absent or is only very minimally involved in the children's lives. In this case, it found that an overriding parental responsibility order was unnecessary and disproportionate. It said there wasn't really any reason for depriving the mother of parental responsibility, and the correct approach was for the court to determine any disputed issues as and when they arose on application being made by either party. The third case I'd like to look at is the case of Tom v. F&F. This is, again, a slightly unusual case. It's from last year, from 2024. And it involved a boy aged 13 who applied for permission to make an application for a lives with order. What happened in terms of the background was that there'd been a long history of litigation. There had been hearings in 2013. There'd been one in 2015, 2016. Then in 2019, when Tom was 10, he said he wanted to live with his father and to move to a school near his father's home. But the court felt that he should continue to spend roughly equal time with his parents and remain at the same school. Then in 2022, when he was due to go up to secondary school, there was a further application, and Tom wished to live with his father, and the court ordered that he should continue at the school preferred by his mother, and following that, a decision was made that he should continue to live with his parents as per the previous shared care arrangement. So Tom, obviously being thoroughly disillusioned by the success or lack thereof of his father in making applications on his behalf, then issued his own application. And he got a solicitor, and he filed a statement saying he was very unhappy living with his mother. He wanted to live with his dad and see his mum and his sister every other weekend. He also said that he wanted to attend the secondary school, which had previously, in the 2022 litigation, been put forward by his father as the school he should attend. And his case was, in essence, look, those are my wishes and feelings, and they've not really been taken into account previously. He had a solicitor, and the solicitor filed a statement saying that, in her opinion, he had sufficient understanding to make the application. Somewhat surprisingly, father supported the application, but mother did not. So the court needed to consider his ability to make the application. And the first thing it had to consider was whether he had sufficient understanding to make that application. That was the first part of the test. Does he have sufficient understanding? And the judge in the case reminded himself of what was said by Lord Justice Jackson in a case called Re C from 2023, where Lord Justice Jackson said this: "The question will be, does this child have the ability to instruct a solicitor in the particular circumstances of the case, having regard to their understanding? The assessment will be based on a broad consideration of all relevant factors and any opinions from solicitors and experts. The assessment will be case-specific, driven by a practical assessment of the child's understanding in the context of the particular case." So that's the first part of the test. But even if the court takes the view that the child has sufficient understanding to make the application, that's not an end of it, because the court retains a discretion, and in exercising that discretion, it has to look at all the circumstances of the case, including the prospects of success, and the child's welfare is not paramount. And in this case, the court considered that Tom lacked sufficient understanding to make the application because he didn't understand the long-term impact of what he wanted on the relationship that he had with his mother and sister. He was unable to put forward clear reasons as to why there needed to be a significant change to both his living arrangements and his schooling. And he didn't understand the extent of harm and upset that might be caused by being involved in a court battle with his parents. Two takeaway points. Although all of this went on, Tom wasn't actually allowed in the hearing. He was excluded from it. Representations were made on his behalf by his solicitor, but he wasn't actually allowed in the hearing. And the second is that the court considered whether you need expert evidence to determine a child's understanding. And what it said is that it's typically a matter for the solicitor whether the child has the ability to instruct, and expert evidence is not usually required. The judge referred to some guidance published by the Family Justice Council in April 2022, and that's called the Guidance on Assessing Child Competence to Instruct a Solicitor, which sets out some useful guidance as to the things to be taken into account. The next case is the case of Re T, and this concerns the circumstances where the court might make an order for a child who's reached the age of 16. Now, we all know that under Section 9 of the Children Act, the court can make an order to vary or discharge an earlier order in respect of a child who is over the age of 16. But otherwise, it can only make an order where the circumstances of the case are exceptional. Unfortunately, the Act doesn't define what exceptional is, and so that's been left to case law. And typically, in the cases, exceptional arises where the child has some learning difficulty and or other quality which requires an additional need for protection. Now, what happens in Re T is that T isn't 16, he's 15, but he's reaching the cut-off point. He didn't want to see his father, and it was clear to the court that this was because of mother's alienation And you're going to hear from Richard about alienation in a moment. Mrs. Justice Arbuthnot said that parental alienation may fall into one of the categories of exceptional. So in other words, potentially, you could make an order in respect of this child. However, she went on and she said that what was clear here was that the boy didn't want to spend time with his father, that it would be wrong to ignore his strong wishes and feelings, albeit they'd been shaped by his mother since he was young. And she concluded by saying, at his age, I must respect his wishes. I accept that this may well be an exceptional case and one where I might have ordered contact to continue, but I take account of his views and I cannot see how an order could be made to work from the age of 16 onwards. So, applying the logic there, unless the child does have learning or cognitive difficulties, whilst parental alienation may fall within the category of exceptional, it's difficult to envisage a case where you would force a child, and even if you did force a child who was 15 or 16 to have contact, how would you actually then make it work? Next case I'd like to look at concerns appealing an arbitral award, and it's the case of P and B. This will be the last case that I do, because I know I can see Richard is just really eager to get up here and to entertain all of you. But there are a couple of other cases which I haven't touched on in the notes, so you might want to read them this evening when you've got a glass of wine in the garden. I'm sure that there's nothing else you'd rather do. So what is arbitration? Well, family arbitration is a form of private dispute resolution. And what happens, as you know, is the parties appoint a suitably qualified person, an arbitrator, to make a decision. That arbitrator will, as a judge might, hear evidence and submissions, and then they will produce a determination. And in children arbitrations, if the parties are going to go to arbitration, they will need to confirm there are no safeguarding issues, and they need to be agree to be bound by the arbitrator's written decision, subject to any right of appeal or other available challenge. Is there a role for the court? Well, yes, because if there's been a determination, you still might want to apply for a court order, not least for the purposes of enforcement, despite the fact that we have the no order principle. Is there a right of appeal? Yes, there is a right of appeal. The parties have a right to appeal to the court on a point of law. They can also invite the court to set aside the award if there's been serious irregularity, which has resulted in substantial injustice. Now, what happens in P and B is the parties attend arbitration for a children dispute. They get the arbitrator's written decision on the 31st of May, resolving all the issues that they'd asked the arbitrator to resolve, including summer holidays. Unfortunately, they're then unable to agree the terms of the draft order, particularly when it comes to what's to happen during the summer holidays. And mother effectively isn't happy with the decision that the arbitrators made and is trying to move the goalposts. So she goes back to the arbitrator and she asks him to reconsider the issue of the summer holidays in the way that sometimes we do after a final hearing when we've had the decision of the judge and we've been sent away to draft the order. But the arbitrator refused to look at the issue of holidays as she'd already determined it, and she hadn't read anything which would cause her to change her decision. So the mother appealed, and the appeal was dealt with on papers by H.H.J. Robertson, and it was held that the mother's application should be considered in 2 stages. First stage, did the application have a real prospect of success, or was there any other compelling reason why the appeal should be heard? And then the second test is, well, if you can get over the first hurdle, then the case will be set down for review, at which the question will be asked whether the arbitrator was wrong. Now, there were a number of challenges that the mother made to the arbitral award, but the first and probably most significant ground of challenge was that the arbitrator had erred procedurally by deeming the issue of the summer holidays to be res judicata, to have been decided, and that she should have been willing to reopen the issue. And what she said in her argument in support of that was that a judge has the power to reopen their judgment or order at any time after the judgment until the order's been sealed, and that accordingly the arbitrator has the same power. H.J. Robertson said, no, they don't. Said there's no duty on the arbitrator to reconsider her determination. Judge and arbitrator are not the same. There was no agreement that the arbitrator should reconsider the issue, and if the arbitrator was going to reconsider the issue, then the parties needed to agree that that was the case, and they hadn't. And I think that my time is up. Thank you very much.
So my job is to dip our collective toes into the whirlpool of parental alienation. I start you with some questions you can think about as I go through the talk. Do we treat parental alienation with the same level of seriousness as we treat domestic abuse, controlling coercive behavior? It's 11 years since Mrs. Justice Parker said this. In Re-H, I regard parental manipulation of children, which I distressingly see an enormous amount, as exceptionally harmful. It distorts a relationship of the child not only with the parent, but with the outside world. Children who are subordinate to flouting court orders are giving an extremely damaging message about the extent to which authority can be disregarded and given the impression that compliance with adult expectations is optional. She went on to say, parents who obstruct a relationship with the other parent are inflicting untold damage on their children, and it is, in my view, about time professionals truly understood this. Do we think we do? In a lecture to the Families Need Fathers conference in 2018, the president said this: in some cases, a parent can, either deliberately or inadvertently, turn the mind of their child against the other parent, so that the child holds a wholly negative view of that other parent, where such a negative view cannot be justified by reason of any past behavior or any aspect of the parent-child relationship. In 2018, His Honour Judge Bellamy talked about a body of research evidence and an increasing body of jurisprudence that accepts that in some cases children do become alienated from a parent, and that sometimes that alienation is caused by the other parent. In 2019, His Honour Judge Wildblood said, it's my impression that she, in respect of a case, a mother in front of him, has at best allowed the demonization of the father, and at worst actively encouraged this demonization on the basis that it is right to do so. She is unable to perceive herself as being an agent or a cause. 2023, of course, we have the President's landmark decision, which effectively draws a line in the parental alienation syndrome. It's often forgotten that because parental alienation syndrome has been roundly discounted, parental alienation per se hasn't been. And you often get, I'm afraid to say, some eye-rolling when parental alienation is even mentioned as a concept, with people forgetting that it's a syndrome rather than the underlying behavior that has been ruled out of order. This is not exactly a non-controversial subject. Women's Aid described the whole concept of parental alienation as a dangerous and a harmful concept. The UN, or one of the UN bodies, described it as a pseudo and regressive theory. The NSPCC also has some other choice words to denounce the use of parental alienation as a concept. Rights of women, again, say the validation of a belief system that has no place in the family court. The court can exacerbate problems between parents, lack of emphasis on the importance of the voice of the child, failure to acknowledge the importance of domestic abuse, sexual abuse, and child abuse. Now, why? Well, it's quite obvious that in so many cases we deal with, when there are allegations of controlling coercive behavior or domestic abuse, the counter-allegation is, well, she or he has alienated little Jimmy against me. Some recent research from the University of West of England in 2025 suggested that in 40% of divorces or parents that were separated, one person was saying their ex-partner had attempted to turn their child against them. Well, the whole syndrome issue came to the fore back in 1992 with Richard Gardner effectively forming The View and setting a trend to label the behavior behind parental alienation syndrome. That was roundly discounted by Joan Mayer in 2013, who labeled the syndrome junk science. Science has never settled, is it? In the United States, supposedly grown-up scientists, grown-up psychiatrists are now saying, actually, Joan Mayer may have got this wrong. And there is increasing build-up of research and jurisprudence in the lower ranks of some state courts in the US to treat parental alienation yet again as a pathological condition. The US National Institute of Health has specifically said 19% of the population in America has been exposed to alienating behavior on the part of their parents. The backlash, of course, is that, and I choose these quotes advisedly, some people said, well, this is a whole sort of Nazi theory, burning witches theory coming back into fore. There is a new school of thought in the States that probably one day will hit us in some shape or form, that is actually a psychiatric condition in and of itself. And lots of people there are now saying DSM-5, parental alienation syndrome, doesn't exist per se, but it is and should be treated as one of those other conditions that may be a focus of clinical attention. I say no more about that. We tend to move in waves and cycles, so watch that space. What is parental alienation or parental alienating behavior? Well, for example, saying negative things about the parent in front of the child, encouraging child to take sides, making the child believe the other parent does not love them or want to see them or spend time with them, making the child feel guilty for wanting to spend time with the other parent, not allowing contact between the parent and child, encouraging defiance towards the other parent. What are the signs? Classically, child may suddenly be reluctant to see the alienated parent, even if they were previously very close. Start saying things in adult language that could only ever have come from the alienating parent. Simply withdraw, which can make it hard to figure out what's going on. Child expresses extreme disapproval of the alienated parent without justification. Absence of guilt, remorse for mistreating the alienating parent. Rejection of the alienated parent's extended family and friends, lack of ambivalence about the alienated parent, seeing them as all bad. Child claims to have formed negative opinions independently without influence, which is something no child ever does, really, do they? Child denies any positive past experiences with the alienated parent. Child displays unjustified anger or fear towards the alienated parent. Well, there can't be many of us who haven't had a client in front of us saying, well, that's exactly what's going on. And then you have to think to yourself, well, how on earth do you prove any of that? What can be done about alienating behavior? If it is alienating the child, well, therapy, changing residence, imposing restrictions on contact arrangements, warning the alienating parent they may be fired or sent to prison if they continue with the alienating behavior, and in particular serious cases, getting the local authority involved, which in some circumstances could lead to care proceedings. Reminder of a case I dealt with some time ago where we had a High Court judge take a child into care 6 months to decompose from the treatment they had had at the hands of or the alienating treatment they had had at the hands of their father before placing back in mother. It didn't end happily. Damage had been done. Children then left mother and went back to live with father. So if you remember, only 6 months ago, in December 2024, the Family Justice Council produced guidance on responding to a child's unexplained reluctance, resistance, or refusal to spend time with a parent and allegations of alienating behavior. And at the front of that document is a neat glossary, the new lingo we all need to get used to. So AAA, attachment, affinity, and alignment, reasons why children may favour one parent or another, or reject a parent, which are typical emotional responses to parenting experiences and not the result of psychological manipulation by a parent. People forget that the relationship between a parent and a child doesn't just happen, doesn't just come out of nowhere when parental separation takes place. It's a lifelong experience, and children do develop likes, dislikes, favourite parents during the course of the time they've had with that particular parent. AJR, appropriate justified rejection, a situation where a child's rejection of a parent is an understandable response to that parent's behaviour towards the child and or the other parent. Alienating behaviour, AB, psychologically manipulative behaviours intended or otherwise by a parent towards a child, which have resulted in the child's reluctance, resistance, or refusal to spend time with the other parent. PB, protective behaviours, behaviours by a parent towards a child in order to protect the child from exposure to abuse by the other parent or from suffering harm or greater harm as a consequence of the other parent's abuse. And the 3 R's, reluctance, resistance, or refusal, behaviours by a child concerning their relationship with or spending time with a parent, which may have a variety of potential causes. So there are 3 elements that the court has to consider, and you have to consider in giving advice to your clients when they come in through the door, saying, Mummy has been alienating little Jimmy from me, or vice versa, and we often forget in this scenario. You've got to look at these things and treat these things in a gender-neutral way. There are just as many allegations going the other way of fathers who have primary care alienating mothers. So don't think of it as some form of mum's rights versus dad's rights arguments. You tend to have this when you have a primary carer, a secondary carer, or a non-resident parent making these allegations. They may be right, they may be wrong. But the first element is the child reluctant, resisting, or refusing to engage in a relationship with a parent or carer? I can't be the only person in the room who's had someone come up to me and say, conference, it's parental alienation. How many times a week do you see your child? 3 times a week. Is it really? Is that alienation? Not really. There may be underlying other behaviours going on there, or misbehaviours going on there, but that's not really alienation per se. And this leads to another problem, because if a child is not seeing the non-resident parent or the applicant for contact, how do they establish, on the basis of no real feedback from the child, that there is alienation going on? The second element, the reluctance, resistance, or refusal is not consequent on the actions of the parent towards the child or the other parent, which may therefore be an appropriate justified rejection by the child or is not caused by any other factors such as the child's alignment, affinity, or attachment. Remember what I said, children develop an alignment with one parent, if not both parents, from a very early age. And lots of people, when they get divorced, suddenly realise what they've missed, don't they? And they then want a relationship with a child they never really had when their parents were together. So where's that? That goes into the alignment test. The affinity, again, it's all about personal chemistry. If you don't have a personal chemistry type relationship with your kid before separation, you're highly unlikely to have one after separation, and that's something lots of dads in particular tend to forget. But then we've got the reluctance, resistance, or refusal consequent on the actions. This is all about actions rather than psychology or syndrome, and an appropriate justified rejection. Well, when you've got, for example, a domestic abuser and the child's experienced that and picked it up, rightly or wrongly, from their home life, is it an appropriate justification? I don't want to see him again. I don't want to see her again. Or is it not? There we get into facts and degrees. And the third element, the other parent has engaged in behaviours.
that have directly or indirectly impacted on the child, leading to the child's reluctance, resistance, or refusal to engage in a relationship with that parent. Again, think through when you're listening to this. How do you prove that? Well, the guidance suggests courts have to triage these kind of cases. And of course, remember, make every hearing count in the application, in the first position statement at FHDRA. Court has to consider the seriousness and substantiated nature of the allegations. So this is where eye-rolling comes in, doesn't it? Because all too often you come to court and you've got the vaguest of allegations that only come out later. Domestic abuse cases, that tends to be excused to some extent, because obviously it takes time to admit to the experience people have been through. Parental alienation, we tend to give short shrift, don't we? If people don't have that substantiated case right from the start. But of course, people don't realise at the time they issue the application. These are learning curves for everyone involved in the family justice system. But if you've got over the stage one with the seriousness and the substantiated nature of the allegations, it should be reallocated from magistrates to a district judge. Always remembering that simple assertion is not enough. So, headlines, what is the evidence? What evidence do you have? Take instructions from your clients before getting to court for the first time. Is contact actually happening, or is it not? Is resistance justified? Is a fact-finding hearing relevant, necessary, and proportionate? Think through. How else do you prove parental alienation without a fact-finding hearing? Well, here we come into the interplay between domestic abuse and parental alienation. If Mrs. Justice Parker was right, and the orthodoxy, until relatively recently, that hasn't disappeared because of the President's guidelines and the disappearance of syndrome as an issue, are we really taking parental alienation as seriously as domestic abuse? It's often knee-jerk said, perhaps, that if domestic abuse allegations are made out, well, parental alienation allegations of themselves cease to matter, disappear. Well, is that actually right? When we know from the research that goes on these things, just because one person is the key domestic abuse perpetrator, it doesn't mean there wasn't domestic abuse the other way, in a gender-neutral evaluation of what went on. And just because someone is the perpetrator, the victim of domestic abuse, it doesn't mean that they are also alienating a child. You've got to balance those issues. It's not a binary did or didn't happen in terms of that interplay. CDM and CM from 2023 was the instance, the case that perhaps you need to remember in terms of when you get the local authority involved, because obviously local authorities don't like getting involved in private law cases for resource and all manner of other issues. But there are times when you need to get a Section 37, an interim care order, a removal, readjustment, replacement. I think I mentioned that earlier. Now, in the CAFCAS guidance, which you'll find online, there's a handy checklist, a toolkit, and it's basically a tick box exercise. Very rarely seen anyone else use this in court or cross-examination of CAFCAS officers on the basis of what have they actually found in respect to these particular points. So it's divided neatly into behaviours of a child, behaviours of an adult, and behaviours of a rejected parent. And you've got, I think you may be, or may not be able to see, but there's a checklist there which is uniquely, in my view, necessary to go through in terms of taking instructions from your client. Are these things actually happening? I'll move on slightly because of the time. All available on the internet. The CAFCAS guidance also goes on to talk about, in all cases where children are being harmed, it's important that there is a full analysis of all factors that appear to be contributing to a child's negative beliefs about a parent before a professional view is reached regarding alienating behaviours. We all understand the time pressures Kafkas, Nias, and so forth are under. But Kafkas' own guidance talks about a full analysis. It also talks about a systemic approach in the report, reviewing all possible causes of the resistance or refusal to help the court reach child rather than adult-centered judgments in often highly contested cases. It's a cautionary note to remind Kafkas officers, and indeed everyone else who reads these reports, that because of the polarized nature of the debate about matters as fundamental as its definition and identification, allegations tend to increase in an adversarial court system. Maintaining the focus on the impact of the child at all times and making clear links between the analysis recommendations can help the proceedings becoming adult-centric. Kafkas officers are encouraged to write a concise description of the child and parental behaviors which inform the analysis and be clear about the observations and what conclusions you are drawing about those. Question mark, what do they leave out and what has to be left out? Balance sheet approach is absolutely necessary, highlighting strengths and risks posed by both parents. We are seeking, they say, to ensure that a child has a beneficial relationship with both their parents where safe, so they do not go for their formative years without the benefits of a loving relationship with all significant adults. And then the balance sheet analysis following the Reed-BS from 2013 guidance. Evaluation of the impact on the child of all potential realistic options. Now, I end by going back to the Family Justice Council guidance, because at the back in chapter 6, we may have skipped over this when we first read the document, is the guidance note on understanding reluctance, resistance, refusal, and psychological manipulation. Some headlines from this. It's easy to assume that a child's negative reaction, in particular their initial reaction to parental separation, is a stable and pervasive indication of a decision about their desire for a relationship with a parent, or that resistance at some level will be implacable or unchanging. In response to parental separation, children may be expected to experience a wide range of emotions, those 7 circles of hell and the like, and react with initial anger or resentment due to the situation they find themselves in, and for this to be directed at the parent that they perceive to be at fault for the relationship breakdown. So you see, in that particular paragraph are all the pros and cons of early intervention, but also reviews. Children do change their mind over time, and when dad or mum walk out of the door and they're left with a resident parent, whose side do you think they're normally going to be on? The next paragraph talks about the resistance may include a range of behaviors from refusing to speak to or see a parent, throwing away things they associate from, to angry and challenging reactions to that parent, making derogatory remarks about that parent to others, teachers. Example. None of these behaviors, it says, can in themselves be taken to indicate evidence of exposure to psychological manipulation. It can be helpful to consider the reaction to the relationship breakdown around them as a loss reaction. It's effectively bereavement, isn't it? And all the emotions one experiences when one is bereaved. And consider that observed behavior may alter over time as this loss is processed by the child. Query, what use really is a Kafkas report that's 9 months old in situations of evolving dynamics? The next paragraph, important to recognize that there will be situations in which there is no obvious cause or reason that can be identified for a child demonstrating RRR. The lack of a rationale or explanation may cause there to be concern that the child has been exposed to psychological manipulation. But the absence of an identified justification does not in isolation evidence such manipulation. Crucially, and I end with this, it is when there is no known justification for the rejection of a parent in combination with evidence of psychological manipulation that it may be determined that the child is in what is sometimes referred to as an alienated position in the family dynamic. When you look at the research papers, as it were, pro and for, the syndrome and pro and for the whole situation, you'll find it's heavily laden with what might be called culture war issues. And there are lots of arguments that we really fail to get to grips with, if I may say so, in the family court, simply because we do not have time to do that or the resource to do that. But that, of course, doesn't mean we shouldn't try. Thank you very much.
Thank you very much, Richard and Jeff. Now looking at a more positive approach, as Richard has just urged everyone to do, we've got Kerry Moss from CAFCAS talking about the Parenting Together programme.
Yes, that's right. Hi, everybody. I'm Kerry. I work for a charity called Action for Children. So we work alongside CAFCAS to deliver the Planning Together for Children course out to separated parents. So we are the main provider along with our 6 subcontractors. We've been delivering it now for 2 years. This is our 3rd year, just coming into our 3rd year. So there we are with CAFCAS and all of our 6 subcontractors. So today I'm just going to give you a quick overview of the start to the finish of the course, and then we do offer more tailored courses, usually via Teams, if anybody wants to have a more in-depth look at the course content. Okay, help me, this one. Okay, so what is Planning Together for Children? So Planning Together for Children is an England-wide online course. It supports parents who are separating or living apart to put the needs and best interests of their children first. Parents will learn how to protect their children against some of the harmful effects that can arise due to parental conflict. During the course, parents or those who care for children will explore how they can work together to agree on parenting arrangements without the need for more court hearings, learn how disagreements and arguments can affect children so they can minimize them. So Planning Together for Children replaces the old Separated Parents Information Programme, as it used to be called as the SPIP. The programme is now made up of online learning and then an interactive live digital group sessions and then impact feedback collected. So the SPIT programme was prior to COVID. COVID hit, we had to move that programme online, virtually. We were getting good responses, but CAFCAS recognised that if we were going to keep doing this digitally, we needed to have a new digital platform to do that from. So this is where Planning Together for Children comes from. So the aims are to protect children against some of the harmful effects of parental conflict. Gives more time for engagement and reflection by participants. The impact of the course is recorded so that things can be adapted over time. Aims are to reduce the time families spend in the court proceedings, and aims to reduce the number of families returning to court. So here we are, Action for Children. So the contract is led by Action for Children in collaboration with our delivery partners. And we cover the whole of the UK. And 24-25, we received just over 28,000 referrals to deliver the course. Each provider follows the same course content and follows the programme fidelity. We all do peer observations across different subcontractors to make sure that we are all delivering the same, programme and its content so that everybody, all attendees, whoever they go to, have that same experience. So this is how it looks sort of from start to finish. So a referral can be made by FCAs, Family Court Advisors. They can recommend the programme. If both parents are wanting to attend, then that referral can come through to CAFCAS, which then comes through to us. If one of the parents doesn't want to attend or neither doesn't want to attend, it will then get picked up in court and be made court ordered. So in the end, everybody that goes to court for a child arrangement order will have to do the course. Obviously, there's different safeguarding issues and things like that, but everybody that comes through and gets referred are deemed safe to be completing the course. So, firstly, initially, they will receive a letter from CAFCAS, an email from CAFCAS, asking them to make a portal. So they go into the portal and they make their account. Within that account, they've got their e-learning. We'll look at these in a minute in more detail for you. Once that e-learning is complete, they then get booked onto a group work. And a group work is via Microsoft Teams with myself, one of my colleagues, with up to 6 parents. Never 2 co-parents together, always separate. Once we've done the group work, we then have a stage 3, which is the follow-up call. So they can opt in or opt out of 6 weeks after they've completed to have a follow-up call, just for us to gather any evidence, if things have got any better, stayed the same, how they're finding things, do you think the children have noticed any difference? And then on to the parenting plan. So the parenting plan isn't mandatory. It doesn't have to be completed, but we do like to talk about it quite a lot, as you'll see when we go in through the group work, of what it looks like and how it can work for some families. So this is the stage 1. So this is what it looks like when your parents log in to their portal. So initially, they'll have to go to the login. They'll have to put in their email address, which needs to be verified by CAFCAS. That's really important. If it's not verified, then we can't get hold of them. They're not on that system. So this is the e-learning, and this is split. Logs in and completes that e-learning independently. So this is now split into the 9 modules. So we have the purple ones are the modules: welcome and introduction, what happens if I go to court, understanding and managing emotions and feelings better, how does the way we handle separation affect my child, putting myself in my child's shoes, what can I and my co-parent do differently to support our children, how can I listen and communicate better to help my child, tips to help me remember how to listen, talk and communicate in the future, and what am I going to do next? And you can see also that there's 3 surveys within that. So we have one at the beginning, one in the middle, and one at the end. And that is driving our feedback as to different objectives of what CAFCAS want to get out of this course material. So these are all completed. They are approximately about 10 minutes each. So it takes sort of just under an hour, and they can all be done separately. It's not got to all be done at the same time. So I'm not sure if this is going to work on here. No, it's not. Okay. So e-learning access for professionals. So I'm going to quickly go over this. So if you have a CAFCAS or judiciary email address, then you'll be able to log into the system and have a quick look at that e-learning for yourself. If not, like I say, we do hold sessions where we can do this and show you what they're going through the e-learning session. So this is the group work. So this is the stage 2. So once that e-learning has been completed, they will then receive an email from ourselves with logging into our own portal then with various different times, days, weeks of what we've got available. So for example, we personally, Action for Children, run about 50 sessions per week, mornings, afternoons, evenings and weekends. So we try and cover everybody through work, through contact, through everything else. Like I say, they won't be on the programme with their co-parent. We deliver with up to 6 other parents. And we can provide individual needs support where required. So I am actually the parental support coordinator. So anybody unable to follow the whole process online will come to me, and then I'll reach out and my team will help and support them to access It might be that they don't have Microsoft Teams, don't have a device that can access Microsoft Teams, they can't even get into the portal, they haven't got tech to get them in or the knowledge. So I've got a nice small team at Action for Children that work together with these parents that actually cannot go through the normal route to access it. Again, they just come to me and we sort out whatever need is required. Within the last 12 months, we haven't had to do any face-to-face. So first year we had to do probably half a dozen face-to-faces where everything we couldn't do, everything wasn't working. But this last year we haven't had to do any because we've been able to meet everybody's needs virtually. And then once the completed feedback is submitted, that goes off directly to CAFCAS. So at the end of their group workshop, feedback on the course content, how relevant it was for them, how was the facilitator, is there anything the facilitator can do better, is there anything else that they want from us, because we're not just here to deliver a course and then go. They can then opt in for a stage 3 call, again another call from a facilitator to see if we can help anymore, and we can signpost to lots of different organisations to help and support with that. So this is some of the group work. So we do have section 1, which we look at separation and the negative impact of parental conflict on children. Quite an intense section at the beginning, because we really hammer down on how the conflict that is going on in your lives, you may not realise it's happening for your children. You may not see it like that. So we really look at actually putting these parents to stand in these children's shoes and actually try and look and reflect on what their children are living right now. So we go through that one, and then we go on the second section is how to best manage conflict and improve communication for child-centered parenting. We then take a look at the parenting plan, and then the next steps are the feedback back to CAFCAS. So this is just one slide of one of the questions and scenarios. It's a very engaging course. We're not just there to give out information. It is about getting the parents to think, to reflect, to be open and honest. We do try and make it a real nice safe space. We break down any barriers that they have so that they can try and be really open and honest with themselves. They don't have to feed back to us, but if we can get them to be open and honest with themselves, then that really makes a difference. So one of the slides here, we just look at how name some feelings that your child might feel in these scenarios. 9 times out of 10, we're going to get, well, that doesn't happen. That doesn't happen. So we try and get the parents to think outside that box. Okay, it might not happen for your children, but what if it did? You know, it's about looking at how children would feel with these simple scenarios as a parent showing up late, parents arguing, one parent asking their child to pass messages, and then not having both parents or carers at school events or parents' evenings. So just prior to this slide, we do look at the iceberg effect, which really hammers down some of the feelings, the negative, strong feelings that children may feel when their parents are going through separation. And they're having to live through a lot of conflict. So then what we do is we try and get the parents to think back to that slide and think about some of those behaviours. And again, we really start to see how children can really relate to what their children may be going through. So at the end of that section, we then go on to the parenting plan. Again, we say it's not mandatory, so you do not have to complete this, but it is a very good tool if you can. The parenting plan can be accessed direct on the CAFCAS website. So, you know, you don't have to be going through that court process. To get the e-learning, you have to go through the court process, but just directly to the CAFCAS website, you can bring up the parenting plan. So those parents that are not referred yet can actually still access the parenting plan prior to coming on to the session. Again, the parenting plan is not a mandatory part of the court process. It should not be completed if there are ongoing safeguard concerns or risks of domestic abuse. Ideally, if it is appropriate to complete a plan, this should come at the end of the learning journey, and the trainer can advise and support on this. So again, we offer separate sections if there's anything that we can help with parents to complete the plan. So how is a referral made? I did touch on this earlier. So it can be recommended by a family court advisor, or it will be following a court order. And this replaces the SPIP records and SPIP referrals. So who can be referred? Unlike with the SPIP, where we could self-refer, there's no self-referring for Planning Together for Children at the moment. So Planning Together for Children is for parents and adults with caring responsibilities in private law family court proceedings. So we do have grandparents, many grandparents attend, aunts and uncles, older siblings, anybody that has that parental responsibility for a child and then they're going through the court for contact will be referred to attend. So what can you do to support parents and carers? Ensure that contact details are completed on referrals. Encourage parents to verify these details with CAFCAS. Make participants aware of the expectations and encourage them through each stage. So now you're going to have more of an idea. They've got the stage 1, which they do by themselves whenever time suits them. They will then have to book onto a stage 2, which is a 2.5-hour session. But like I say, mornings, afternoons, evenings, weekends, we can do them to suit. We have various times for them. The stage 3, again, if they want to do that stage 3, they can have that stage 3 callback. So it's just really important that you are aware of the stages and can help and support the parents through those. And then share as much information about the session before to parents and carers who are expected to attend. So the majority of cases where domestic abuse has been assessed within proceedings conclude with some form of contact, including letterbox, video calls, supervised, supported or unsupervised arrangements. It is therefore likely that those attending PTFC, even if domestic abuse is a concern, will need to safely manage future arrangements for their child or children. Cases should not be recommended if there is a reasonable likelihood that the parents will need to communicate regarding their child now or in the future. So cases that should not be recommended or referred to PTFC, if there are significant allegations that, if proven, would preclude any form of safe contact. That it's assessed that the impact of trauma on the victim is such that they could not support any form of contact with the perpetrator. The child's wishes and feelings are determinative and they would resist any form of contact. And the court may direct attendance at the PTFC without a recommendation from CAFCAS. The court have received guidance when it is appropriate or not. So even if a family court advisor suggests that it's not appropriate, the court can go above that, and if they feel it is still appropriate, then they will still refer that. And then there's just helping Planning Together for Children. So CAFCAS do have their own Planning Together for Children on their website, and there's a few contact details. And if anybody wants to know how they can book on any more professional sessions, like I say, we do hold 2 separate sessions at the moment. We have an hour session which looks into more detail of the professional side and how it's all run. And then myself and my my facilitators, we run actual sessions where we go through the course content in more detail so you can see slide by slide of what the parents are going to be reading about and learning about. Okay, so that's very quick and concise. Time for questions, if anybody's got any questions for me. No? That's good. Thank you. Thank you all.
Thank you very much, Kerry. And we've got lots of useful links in the notes that are going to be sent out afterwards. And Kerry, I hope you'll be able to wait for a cup of tea and you can probably answer some questions at that point. Now, back to Richard Balkin, who's going to talk about non-court dispute resolution.
So I think we all know that there isn't a magic pot of money coming in the direction of the family court system. And the emphasis we're getting is that we need to try and resolve more cases outside of court. You should have by now picked up that we've changed the lingo again from ADR, alternative dispute resolution, to NCDR, non-court dispute resolution, with the idea being to get as many cases out, privatized as it were, into settlement outside the court system than inside the court system. Eat more biscuits. It's a tough old world when you're doing a private FDR or an arbitration, because you're not stuck with the court coffee, if there is a court coffee machine, and you eat a lot more in terms of biscuits. E&E, early neutral evaluation, is perhaps one of the cheaper options, hence the single pound sign. What is it? Well, the idea behind it is you go to a neutral lawyer who's not the party's lawyers, and you get brief submissions, or what would you like, a very informal kind of hearing, if that's the right word. And the evaluator will say, well, look, this is probably what's likely to happen, A, B, C, D, E. The idea is that you're not going to an early neutral evaluation having done all the groundwork, having spent months in correspondence, litigation and the like. But it's there to give the parties a third lawyer's view as to what would happen if the case did go to family court. We're all familiar, aren't we, with our clients telling us what they want, not hearing the advice about what they're not going to get and what they're going to get, but magically want someone else rather than their own lawyer to tell them what is going to happen. An early neutral evaluation in both financial and children cases is meant to be the way we should be going forward. Private FDRs. Well, we've got the £3 signs there because it's not a massively cheap process. It's cheaper than going to court, but you have to pay quite a lot of money for a private FDR, I hate to use the word judge, or evaluator, to conduct the hearing. They've got to put as much time as the parties' representatives, if not more, into reading the papers, producing beautiful spreadsheets, and coming up with a written indication during the course of the morning, so the parties can then go off in the afternoon to do what they would do in a crowded court building. Disadvantages, obviously, we've got the money. Advantages, massive success rate. And the parties here, as it were, the third lawyer, giving their indication about what would happen if this case went to court. But you've also obviously got to put in almost, if not more, of the same effort as you would to prepare that case as going to a court-based FDR. It really only works if parties have done the groundwork. E&E, if you're light on information, and just want the tips, the general indication. Private FDRs, if you put in the groundwork, you're much more likely to get a very considered decision. And most private FDR evaluators will do their own spreadsheet, hand it down, so you can consider all the options, and a written indication,
which is something obviously judges in court doing an FDR list don't have necessarily the time to do. And then you can come back in the afternoon and have further advice. My experience with private FDRs is probably just as much success rate as the court-based FDR, but a lot quicker if you've got your act together and your clients are willing to engage in the process. Of course, some clients will go through the process of a private FDR and not take the evaluator seriously because they're not a proper judge and they want their day in court. So that's always something you've got to be aware of. But sometimes it's also nice to have a comfy armchair to sit down on, a breakout room and all that sort of thing, rather than conduct your negotiations outside the loos in the corridor in court. Arbitration, we've already touched on that. Jeffrey touched on that with the appeal from arbitration route. Again, it's taking off slowly, but lots of big money cases are now being decided by process of arbitration, except where you've got dodgy dealings, where one side wants to expose all in court and the Daily Mail law reports, and the other side doesn't. It's become slightly less attractive now the right of appeal has been extended, effectively, to arbitrations. Previously, it was all hush-hush. Nothing ever came out of that. Nobody ever needed to know anything that was going on. But because you've got that right of appeal, to a certain extent, the golden factor about arbitrations has somewhat evaporated, and that's why people perhaps are going to private FDRs more. But arbitration, again, has its advantages in terms you choose a quote-unquote judge arbitrator to do the business with you. Obviously, you have to pay them, and there are an awful lot of retired High Court judges and senior silks making a lot more doing this than they ever would have done in practice. So you get the benefit of whoever's doing it. You can choose your price range from the low to the extremely high, and therefore you shouldn't think of this as something that only the exceptionally wealthy go to. Obviously, you have to sign up to it. It has to be by agreement. I think my experience is that the courts are very happy to effectively stay cases for the purposes of parties going off to a private FDR and indeed arbitration, and then lodging the consent order once that's all been done. I don't know what the statistics are, but my experience is quite a lot of consent orders now come as out of private FDRs and arbitrations. And in deciding whether that's something you wish to, as a judge, put your imprimatur on, I think it's always helpful that the parties have had that process to at least persuade the court that the statement of information that comes with it has actually been thought through before it's been lodged. We have, of course, got mediation, and everyone has got their own view on the success rate or failure rate of mediation. It can be extremely inexpensive. It can be very expensive. And I suppose what I want to leave you with is you can't have it all, can you? You can't justify the expenditure on all those potential non-court dispute resolution options. You've got to choose the right one for your particular client and discuss all the benefits and disadvantages of each one with your client before a decision is made. Quite obviously, arbitration, decisions made, subject to appeal. Private financial dispute resolutions and early neutral evaluation, parties reach an agreement by consent, which is often, one would have thought, the best way to go. But arbitration, again, can deal with niche issues as well as the full Monty, as it were, So if you've got a small issue and a lot of money, arbitration might be the quickest way to resolve it and also take out unnecessary hearings from the court list. Does anyone have any questions they would like to ask? No. Well, I end with the obvious. Counsel's advice. How many cases would settle if that was obtained earlier rather than later? There we go. Thanks very much indeed.
Thank you very much again, Richard. Now it's time for tea, which will be served at the back again, and then if we come back in sort of, I think, 25 minutes for the finance sessions.
yeah, look, are these your notes here? Oh, Rod's. Yeah, fine. That's all right. That's Rod's.
Right, good afternoon, everyone. We're now going to start the last session